morning, ladies and gentlemen. Today's session, we're going to focus on study unit 15, customary marriages. I hope I am very loud and clear, and you must enjoy the session. So, in customary marriages, so I'm basically going to share with you the introduction of the customary marriage. As you know, you've seen maybe the act, the recognition of customary marriage act became active in 1998. The reason for that was because customary marriages were among the Black community and were included the polygamy marriages. So the reason it was not recognized then is because it formed one of the marriages that were not recognized in Western, or I could say Roman law, which was polygamy. So customary marriages have been enjoying full recognition as valid marriages in South Africa since 1998. The normal consequences of a civil marriage are also applicable to parties in customary marriages. The marriages entered into before coming into the existence of the Recognition of Customary Marriage Act were considered valid only if the marriage complies with the customary law requirements for a valid marriage. Where a bride was to publicly declare before officials and witnesses about her free will and consent regarding the marriage. In case of a minor wishing to enter into a customary marriage, their parents or guardians' consent was of essence. Customary marriages now entered after the coming into operation of the Act. The marriage is only valid if both the bride and the groom are 18 years of age or older. Both the bride and groom consent to the marriage, and the marriage has been entered and negotiated into or celebrated according to with the customary law. This you're going to find it in the Act, Section 3(1), where it talks about the requirements of a customary marriage. So you can see the difference between the marriage entered before the coming into existence of the Act and the marriage coming into existence after the Act. The marriages coming into existence after the Act can either be monogamous or polygamous. If the parties are minors, the consent of the parties' guardian or parent is essential. If not, the minor may ask the presiding officer of the children's court to consent to the marriage. Should that not be obtained, the minor may then approach the High Court for consent. The minor must also obtain written consent from the Minister of Home Affairs or the person designated by the minister. So in this case, after the recognition of the Act, matters concerning the minor were different as compared to before the Act came into existence. So now you can see that the minor had to either firstly have their consent from their parent or their guardian. If they fail to get that from their parent or guardian, they can then approach the children's court for concern, to their marriage. So should that not go as planned, should they fail to get the consent from the children's court, then the children, the minor, may approach the High Court for consent. With the High Court concerning to their marriage, they also need to obtain a written consent from the Minister of Home Affairs or the person designated by the minister. So the minister, if, for example, if the minister cannot assist them at that time, he can also refer them to a person, a designated person who would be approved by the minister. So now the marriage, the customary marriage must be registered by the spouses. However, this is not a valid requirement. What I mean is that should the marriage be should the spouses not register the marriage, it doesn't conclude or render the marriage invalid. So if either parties request the registration, any person with sufficient interest in the matter may request the registration. The registration will occur upon the satisfactory of registering officer regarding the existence of the marriage and its validity. So in this case, for example, you need to bring your letter of lobola and the concern, obviously, of both parties to the Home Affairs, and then your marriage will be registered. This was done easy in the rural areas whereby the chief's men or the officials in the chief's estate would be the one to have record, because they would usually attend such events. So now, because of the new act and the new act where it recognizes such marriages, the registration of marriages can also be done in the Home Affairs offices. So now the patrimonial consequences of a marriage and the control of the matrimonial property. This actually depends on whether the marriage is in fact monogamous or polygamous. Remember, in the beginning, I did mention the reason why the customary marriages were not recognized. It was because they were both they were either monogamous and polygamous. So that had an issue with the law then. However, now it has been recognized, customary marriage has been recognized as a valid marriage, as a lawful marriage in South Africa. So now things like your patrimonial consequences fall into the customary marriages, and the matrimonial marriages, matrimonial property also falls within the customary marriages. So we're going to focus firstly on the patrimonial consequences of marriages and control of matrimonial property under monogamous customary marriages. So there was a case that was discussed regarding the monogamous customary marriages, which is the Gumede case. You can check that in your textbooks. Even I think in your study guide, there's also a brief of it, a summary. So in this case focuses on section 7, subsection 1 of the Recognition of Customary Marriage Act, which provides that customary law govern the patrimonial consequences of all customary marriages concluded before the Act came into operation. The effect of this application was that the husband owned and controlled the family estate, and the wife had no claim to it. The Constitutional Court held that excluding the wife to claim from the family estate on the basis of the date of marriage was entered into was unjust and unfair discrimination on the grounds of gender. Therefore, Section 7.1 was declared unconstitutional and invalid relating to the monogamous customary marriages. Section 7.1 still applies to polygamous customary marriages concluded before the Customary Act came into existence. Section 7, subsection 2 of the Act applies to every monogamous customary marriage, regardless of the date which the marriage was concluded, and the matrimonial property system rules that apply to civil marriages also applies to monogamous marriages. So, which means that the rules of the matrimonial property which are applied in the civil marriage also applies to the monogamous customary marriages. So the patrimonial consequences of a marriage and control of the matrimonial property under polygamous customary marriages. It operates it focuses on the marriages entered into before the coming into operation of the Act. The rank of the house and the wife is determined by the ranking system adopted by a particular group. It could be an Ndebele group, a Zulu group, a Tswana group, or a Tsonga group, or a Venda group, etc. This only applies to native groups. Example for the date of the marriage: the first wife is regarded as the chief wife. The simple ranking system household, the assets acquired by the spouses become family property. The wages earned by the particular wife and her children and the lobola paid for her daughters belongs to the wife's house. So, for example, if you are maybe the third wife, and then your daughter was to get married, the lobola goes to your house. It's not a collective family estate. Marriage is now entered after the coming into operation of the Act. So we're going to focus on the court approach contract. Section 7, subsection 6 states that a husband who is already a party to a customary marriage and wishes to enter and celebrate another customary marriage must obtain a court approval contract in writing regulating the future matrimonial property system of his marriages. So firstly, if the husband wants to now take another wife under the customary law, he must obtain a written contract of approval from the court. This contract will include how the future matrimonial property system of his marriages is to be dissolved, or how it should operate. Where the existing marriage is in community of property subject to accrual system, for example, the court must terminate the matrimonial property system and effect a division of the property. The court now then must ensure equal distribution of the property, taking into account the family groups affected if the application was granted. The court must also allow amendment to the proposed contract if the conditions do not safeguard the interest of the party. In the case of MM versus MN, this case was heard in the Constitutional Court. So the court held that Section 7.6 does not constitute a requirement for validity of a customary marriage. It only relates to the matrimonial property system, and non-compliance does not render the marriage void or voidable. So in this case, it only states the duty of Section 7, subsection 6, that it does not give a marriage validity or consider the marriage void or voidable. It only focuses on the matrimonial system. The matrimonial property system, in this case, where the contract can provide for the use of a singular system, indicates that one matrimonial property system must govern all the husband's marriages. It is legally impossible to apply community of property to a polygamous marriage, and an accrual system doesn't seem to be a viable matrimonial property system in a polygamous customary marriage. So complete separation of the property system to be the only viable option, where the husband and each wife would retain their own estate. The contract would apply the customary law consequences regarding ownership and control of family and house property to the polygamous marriage, which then will reflect the current living customary law satisfies the constitutional requirement for gender equality. So that is what the court contract will contain regarding a polygamous marriage in regards to the patrimonial consequences and the matrimonial property system. Secondly, we will focus on the alteration of the matrimonial property system. Section 7.4 states that spouses whose marriage were entered into before the coming into operation of the Act can alter the matrimonial property system with the court's permission. So meaning if, for example, they entered into a marriage, a customary marriage, the parties now can alter their marriage system, the matrimonial system, with the matrimonial property system, only with the permission of the court. Where the husband has more than one wife, the wife must join in the proceedings. The court grants the application when there are sound reasons for the proposed change, sufficient written notice given to all creditors whom spouses owe more than 500 rands, and the proposed change won't jeopardize anyone. So these are the requirements that would grant the application of the applicant to the altering of the matrimonial property system. Sorry. Marriages entered into after the operation of the Act. Spouses in monogamous marriages may apply to a court for alteration in terms of Section 21, subsection 1 of the Matrimonial Property Act for permission. Then spouses in polygamous marriages cannot invoke the method to change their matrimonial property system. So now the marriages that came into existence after the operation of the Act, when approaching the court for the alteration, for the permission of alteration, need to come through in terms of Section 21, subsection 1 of the Matrimonial Property Act for the permission to be granted. And spouses who enter into polygamous marriage after the Act has been in operation cannot use any method to change their patrimonial property system. So only those that have only polygamous marriages that have been entered into before the Act came to existence can change under the application granted by the court. A customary marriage that a minor enters into without the requisite consent. The patrimonial consequences if the marriage is set aside, a minor entered into without the necessary consent may be dissolved by the court on application by the minor or their parent or legal guardian. The court may make any order with regards to the division of the spouse's matrimonial property that it deems fit. The patrimonial consequences if the marriage is not set aside. It is unclear what the patrimonial consequences are if an unassisted minor's customary marriage is not set aside. So in the Matrimonial Property Act, the legislature included Section 24, subsection 2, which affords validity to a minor's unassisted marriage in community of property, which is not set aside. So now the unassisted minor can actually rely on section 24, subsection 2. In section 7, subsection 3, and section 10, subsection 3 of the Recognition of Customary Marriage Act, which relates to the position during the subsistence of a monogamous customary marriage and a covenanted marriage into community of property. So these two sections that I've just mentioned, section 7, subsection 3, and section 10, subsection 3, they relate to monogamous marriages and a converted marriage in a community of property. So you need to go check on that, on those two acts. Now the status of a wife. I previously stated that there are the role of the spouses in a marriage. In the customary marriage, it is of essence to understand the role of a woman, of a wife in a customary marriage. I did mention that in a polygamous marriage, whereby a third wife daughter now gets married, the lobola goes to the third wife's estate. It doesn't go to the entire estate of the husband or of every wife's household. It goes to the daughter of it goes to the wife whose daughter is getting married. So the status of a wife, the act abolished the status of a wife of perpetual minority and her husband's guardianship over her in all customary marriages. So I don't know how much you know about customary marriages, but in the past they were identified as patriarchy, whereby the husband was seen or rather identified as someone who oppressed the woman, and the woman was always considered as a minor, meaning that she couldn't enter into any contract without the husband. And when the husband takes her into his household as a wife, meaning that he's taking the responsibility from the father to him, the responsibility shifts from the bride's father to the groom. So now the act abolished that concept. Section 6 of the act provides that a wife has full status and capacity, including the capacity to acquire assets and to dispose them and to enter into contracts and to litigate to any rights and powers that she might have at customary law. This was not the case before the act. The woman was under the guardianship of the husband, meaning that he was considered a minor, as I did explain earlier. So everything that the wife would have acquired before the act belonged to the husband. So now the act provides the full status of a wife and the capacity, which gave her capacity to enter into any contract, to acquire assets, to dispose of them however she needed to, and to litigate any rights and powers in that customary marriage. The wife now has the same rights as the husband, regardless of the number of the wives the husband had. Okay? Now, the termination of the marriage by divorce. The grounds of divorce in a customary marriage are only on the grounds of the irretrievable breakdown of a marriage, which is the same as in the civil marriage. The consequences of a divorce are the patrimonial consequences of divorce, which financially speaking are similar to those mentioned in the civil marriage. The court has the power to make an order in terms of the settlement agreement, to make an order regarding post-divorce maintenance, meaning that the wife, either the wife or the husband, can apply for a maintenance, for supporting maintenance from the wife or the wife from the husband after the divorce. Remember, this will also be mentioned in the settlement agreement, whereby the spouse who needs maintenance will also it will be stated in the agreement, the settlement agreement, that they are requesting for a maintenance. Distribution of assets will also be mentioned in the settlement agreement. Forfeiture of patrimonial benefits and costs will also be mentioned in the settlement agreement. So now the distribution of assets in terms of section 8 subsection 4, subsection A. Prior to the decision in the Gumede case, the court concluded that there was no valid reason for limiting the court's power to redistribute the assets to customary marriages in which separation of property operates. The court further held that a spouse who seeks redistribution of the assets in a customary marriage does not bear an onus to prove if he or she is entitled to have certain assets transferred to him or her. This can also be found in, you read your textbook on page 230 to 231, just to iron out and have a clear understanding. The distribution in terms of section 8(4)(b) empowers the court to make a distribution order, which only applies to be the dissolution of a marriage of a man who has a spouse in a polygamous marriage. So now, section 8(4)(b) allows the court to make a distribution order, and this distribution order applies to the dissolution of a marriage of a man who is in a polygamous marriage. So now the pension interests may not be included from the scope of the court's power to distribute assets in polygamous marriages, which are subject to customary propriety consequences. While including them in the scope of the court's power in all other customary marriages would be an unjustifiable violation of a right of equal or would be unconstitutional. Forfeiture of benefits, which in this case might be lobola, does not relate to the spousal matrimonial property and is not automatically terminated by dissolution of a marriage. So the interest of the children of a divorcing parent, the court, after considering the report and recommendation, the court may make any order that deems fit regarding the guardianship, meaning the court will also consider which parent is to have custody of the children and how they need to operate as in the co-parenting system. This also includes the care contact and the maintenance. This will also be mentioned also in the settlement agreement, whereby there are children involved, and as you know that the court is the highest guardian of the child, and in this case we'll consider the needs of the children, the best interest of the children, which obviously which includes the guardianship of the children, the care of the children, the contact as well, and the maintenance of the children. So this report that the court will be looking into to make that decision must be done by a family advocate. And this family advocate must also investigate the welfare of the child and furnish the court with such. Now, the maintenance under the recognition of the Customary Marriage Act provides that the court must take into account any provision or arrangement that has been made in accordance with customary law. The lobola and isondlo probably qualify as factors in terms of this provision. Now we look at the joinder. The court may order that any person who, in terms of the court's opinion, has sufficient interest in the matter, be joined in the divorce proceedings. So if maybe there's an interested party regarding the divorce proceedings, that person may also be joined into the joint proceedings. Now, the jurisdiction of the divorce order must be obtained from the High Court or the Regional Court of the Magistrate Court. The procedure is similar to that of the civil marriage, and the traditional structure can still be used for mediation of customary disputes. Getting the couple to attempt to reconcile or getting them to conclude a settlement can be done through a mediation of domestic disputes. Now, there is an interim relief which will be provided for awaiting the pending of the divorce. In this case, either spouses may apply for the maintenance during the divorce proceedings. The termination of the marriage by death. The recognition of the Customary Marriage Act is very silent on the termination of the customary marriage regarding death, or in this case, by death. However, the KwaZulu-Natal Code states that death does not necessarily terminate a customary marriage. The deceased husband is replaced, it can then be replaced by the deceased paternal male relatives. And the deceased wives may be replaced by any woman from the deceased family. What it means is that, say for example, your husband passes on and you were married in a customary marriage. The marriage doesn't end, according to the Customary Act, the marriage doesn't end because there is death. The marriages continue, whereby in other native groups, they then proceed the marriage through, for example, if the husband passes on, then the younger brother of the deceased or any male relative of the deceased husband now takes over of the household of the deceased, meaning that this person will act as the deceased, will reproduce and provide and take care of the household. The same applies also if the wife was to pass away. In this case, the death does not end the marriage. They now look for any female relatives of the deceased wife to take over the position of the deceased wife. The maintenance now of the surviving spouse can be instituted as a claim by the surviving spouse against the estate of the deceased until his or her death. The coexistence of a customary marriage and a civil marriage or a civil union. A subsequent customary marriage by a party to a civil marriage or a civil union, where a person is a party to a civil marriage or a civil union, may not be in a customary marriage. A subsequent civil marriage or a civil marriage by a party to a customary marriage. Such a party to a customary marriage may not enter into a civil marriage with another person. Section 10, subsection 1 states that parties are competent to enter into civil marriage with each other, but they may do so. The husband's other customary marriage must be dissolved. Meaning that when you, for example, when you enter into a civil marriage, the customary marriage must dissolve. The consequences now of a subsequent civil marriage. The Act does not adequately regulate the consequences of the interference between the couple's customary marriage and their subsequent civil marriage. So the Act does not provide for the consequences of such marriage. We have come to the end of our session. All the best with your exams. Thank you very much.